Good afternoon, and thank you for joining us. As Greg mentioned, I'm Owen Reese. I'm a civil engineer with Aspect Consulting, and I'm really excited about this afternoon's session on the impacts of third-party lawsuits because Clean Water Act citizen suits are a major factor in stormwater management in Washington, either directly, if you've been on the receiving end of a lawsuit, or indirectly by establishing precedent and driving the compliance activities that permittees use to try and avoid a lawsuit. There's also a mystique about them because they live in the realm of law, and not many folks who've been through one are particularly excited to talk about it. So this session is a great opportunity to hear directly from leading attorneys engaged in resolving those suits from both the plaintiffs' and defendants' perspectives. So we have a fantastic panel this afternoon, and I'm going to briefly introduce all three speakers in the order that they'll be presenting. And then we'll roll right into their presentations, leaving a few minutes at the end for Q&A. So first to speak will be Richard Smith. And Richard is a founding partner of Smith & Lowney, the most prominent law firm in Washington representing plaintiffs in Clean Water Act lawsuits. He's been practicing environmental law since 1993 and sums up his practice as, well, it's all about turning ecological crises that concern our clients into legal, political, or economic crises to convince the agency or business people who have the ability to fix the problems to act responsibly. I first met Richard back in 2007 on an industrial permit citizen suit. And since then we've worked, albeit on different sides, on a fair number of these suits. Following Richard will be Jeff Cray, and Jeff is a partner and environmental litigator with Martin Law. He brings over 26 years of experience in water quality and water resources matters, with particular expertise in the Clean Water Act, CERCLA, and emerging contaminants. He's been lead defense counsel in over 30 Clean Water Act citizen suits. I recently got my first chance to work with Jeff on a project involving a new individual NPDES permit. I was immediately impressed by his ability to leverage his high-level connections to work through some very sticky permitting issues. And our final speaker is Veronica Keithley. Veronica is an attorney with Stoll Reeves who assists clients in Alaska and Washington with complex environmental permitting, compliance, and enforcement matters, and again has a particular emphasis on the Clean Water Act. She's been a key attorney on the defense side of some of the most prominent third-party lawsuits in recent years. My favorite aspects of working as an expert witness with Veronica are her understanding of the science, which is founded in her own previous experience as an environmental consultant, and her clarity in communicating scientific and legal nuance to her clients. So with that, I'll turn it over to Richard.
Thank you for that introduction, and thank you, audience, for your attention late in the day. My name, as you've got it there on the screen and have heard it, is Richard Smith, and I have done hundreds of these lawsuits and know all about them. How do I get my next screen here? There we go. All right, so what is it about the Clean Water Act in Washington that leads to my practice and the mystique that Owen was referring to? The Clean Water Act is an exceptional law, particularly in the United States. It has really ambitious statutory goals in the first section of the Act, in Section 101. These are not what you find in the Clean Water Act, in the Clean Air Act, or RCRA, or any other environmental laws on the federal level except the Endangered Species Act. These are real environmental goals that are very ambitious that could never pass through Congress today. The Clean Water Act is structured so that it establishes a comprehensive NPDES program, which is kind of a one-stop shop. It makes it easy to understand the requirements, puts them all in one place, and defines them clearly. Finally, the Clean Water Act is driven by citizen suits. It was designed to supplement federal and state enforcement with enforcement by what's called private attorney generals. And any citizen is empowered to sue for particular violations of the Clean Water Act, including any violation of an NPDES permit. In Washington state, unlike other places in the United States where I myself have lived, environmentalism is a strong part of the culture here. people really do care, particularly about clean water. There's a lot of data, polling data showing that, that people really do care, particularly here in the Puget Sound region. That is also the reason why we have lots of activists and lots of little groups that are dedicated to this waterway, that waterway, this watershed, this type of fish, whatever. So it creates an environment for plaintiffs' lawyers like myself, where there's plenty of work to be done. We also have lots of water around here and lots of navigable waters that are under Clean Water Act jurisdiction. And we've got lots of rain, making for lots of days with stormwater discharges and a greater awareness of the effects of stormwater. The result of all of this is probably, I don't know for certain, but I think I would bet that Washington State has more Clean Water Act citizen enforcement per capita than any other state. That's my practice. I put on here also a reference to Nature's Scorecard, which is another effort of one of my clients, the Puget Soundkeeper Alliance, to achieve some accountability. That Nature's Scorecard focuses on one particular aspect of municipal stormwater, and that is the implementation of low impact development measures. That may well be of interest. That's a scorecard that compares how well different jurisdictions are doing. So Clean Water Acts are brought under the section of the Clean Water Act called 33 U.S.C. 1365, and it lays out what type of relief is available, which is a key to understanding these lawsuits. The relief that my clients are entitled to if we are successful in pursuing one of these cases is injunctive and remedial relief. In other words, fix it. Fix it and potentially also repair environmental damage that you've done. The second piece that's available is civil penalties. And this is, I'll admit that this is pretty draconian, $55,800 per violation per day. And that's per violation of particular permit condition. So often facilities are racking up multiples of $55,800 per day over an extended period of time, and it gets to be a very big, scary number to the defendants, providing my clients with a lot of settlement negotiation leverage. The last thing that we're entitled to, which makes this whole system feasible, is recovery of our litigation expenses. As you might imagine, environmental groups typically aren't rich with money to pay lawyers. The Clean Water Act citizen suit provision contemplates this and allows us to recover our fees on a time by hourly rate basis, as well as our expenses for experts or whatever else from the defendants when we succeed in one of these cases. Some important aspects of the citizen suit mechanics. What happens when there's a citizen suit? What's got to happen? What are the key issues? The first thing is there's a 60-day notice letter requirement. So before my clients can file any citizen suit, we have to send a letter to the permittee or the prospective defendant, as well as a copy to the EPA and the Department of Ecology, describing particularly what it is that they're doing that we're going to sue them for, how it is that they're violating their permit, with as much detail as we can provide in there. The key question about the adequacy of the notice is, of course, whether 60 days have passed, and whether the notice describes adequately the violations that are alleged, so that the defendant can understand what it is that they're alleged doing wrong. The purpose of the 60 days is twofold. One is to give the defendant a chance to fix the violations. It also gives the parties an opportunity to talk before there's actually litigation and try to resolve things or understand what might be misunderstood. Another important aspect of these Clean Water Act citizen suits is, as I mentioned before, perhaps the permit terms define the applicable law. So there is no need to go beyond the four corners of the particular NPDES permit to research whether someone is violating the law or not. It's a strict liability scheme. If you are violating your permit, you're liable, so long as the violations are ongoing. Ongoing is, arguments about ongoing violations quickly get very medical physical. But in the Ninth Circuit, it's pretty easy to show an ongoing violation. All we've got to do is show that the violation continued on or after the date that a lawsuit was actually filed, 60 days after the notice was served, or that a violation is likely to continue to recur in the future. So that gives us a lot of latitude to argue, for example, that failures to monitor, failure of a defendant of a permittee to collect samples, even though they've snapped to since receiving the notice letter, perhaps they haven't changed any policies, really no personnel changes, whatever, and we may be able to prove in such a case that a future monitoring failure is likely to recur in the future. In addition, because of the strict liability issue, these cases usually are resolvable on summary judgment if a settlement is not reached. So typically they follow a pattern where the parties meet, they talk, they engage in settlement negotiations, and if those fail, there's discovery followed by a summary judgment motion on liability, which usually leads to the resolution of the case. The settlement that my clients typically want in these cases definitely falls into a pattern. And very quickly, that pattern mirrors the relief available. It's the fix, the injunctive relief, and any remedial relief that could be very simple or very complex procedure. It could be that we all know what needs to happen, the defendant does it, we agree they've done it, that's done. Otherwise, there may be some uncertainty or some time that has to pass so that things can be developed and installed, in which case we develop a comprehensive schedule as part of the fix. The second part of the settlement is the penalty part, or rather, since my clients and typically defendants are not interested in sending large sums of money to the federal treasury, we figure out a way to compromise on the amount to send it to something useful in the community. That's typically called a supplemental environmental policy project, SEP. And so that would be some non-party that we would send the money to do something specific with it. Perhaps a habitat restoration program or something like that. Often the most difficult part of the settlements is negotiating the agreeable amount of this payment in lieu of penalty. The third part we're entitled to is recovery of our litigation expenses. And again, like I said, that's just reflects the amount of work that we have to get to the point of settlement. Which types of permits are most frequently enforced? It is definitely the industrial stormwater general permit that is most frequently enforced. That is because there are the most permittees. There are about 1,000 of them. They come in all shapes and sizes, all types of approaches to compliance, all types of sophistication and management, all kinds of challenges that these facilities have. So there's just a big variety, big, small. They're all in that bin with the ISGP, and that permit has some very easily enforceable provisions. Individual NPDES permits that cover stormwater are also a pretty frequent target. Those often have numeric effluent limitations rather than benchmarks for these stormwater discharges, which makes it yet a step easier for us to enforce them. The sand and gravel general permit and the boatyard general permit have both seen, I'd say, moderate amounts of action. They have much smaller universe of permittees, and some different features of the permit that make them both, in certain respects easier, in certain respects more difficult to enforce than the industrial stormwater general permit. The MS4 permits, that's the municipal stormwater permits, there have been a couple of enforcement cases that we've brought on those. Recently, those have focused on apparent inadequacies in program implementation revealed to us by reviewing annual reports and annual program documents. Recently, there has been some interest and some particular targets that we're evaluating, cases we're evaluating where there's some other types of violations potentially of the MS4 permits. The construction general permit does not get enforced very much. That's just a hard beast for us to get on top of. It's the facilities are very transient. Things are always changing, and it's just really hard without someone on the ground, like a neighbor, watching what's going on and documenting it daily to build a case against those. So here's a little bit more. I kind of mentioned some of these things. Targeted violations that we have of these various permits are, of course, we're always looking for effluent limitations. The effluent limitation is a number. If your monitoring reveals that you've exceeded that concentration or characteristic of the discharge that's reflected in, that's limited by the numeric effluent limitation, that's a violation. Benchmarks and response requirements are really where most of the action is under the ISGP, under the Industrial Stormwater General Permit. That's a different kind of scheme where the effluent limitation comprises a trigger, a numeric trigger, that when is exceeded, the permittee has to undertake specific responses. Those responses have to be documented. We can check the documentation. We can find out from inspection reports provided by the Department of Ecology whether people have done their responses. That's something that is very common in our industrial stormwater general permits. This is typically the heart of the allegation. BMP inadequacies, best management practice inadequacies, the permits are pretty specific about what has to be done, about what has to be included in the stormwater pollution prevention plans. We review inspection reports, we review observations, we get tip-offs from neighbors and regulators in unmarked brown envelopes about BMP failures. We assume BMP failures when we see bad numbers. We will allege BMP inadequacies and SWIP inadequacies when we just see bad numbers because it makes sense to us that there's some problem upstream that we just don't know what it is yet. Monitoring failures is another big trigger. This whole permitting scheme, the ISGP permitting scheme, doesn't work unless the permittees do their monitoring so that they can have feedback about how their BMPs are working and know to improve their BMPs if they're not making their numbers. Permittees who fail to monitor are highly suspicious to my clients. Repeated quarters without monitoring data will prompt us to investigate. Annual failures to monitor four times a year as required by the permit will cause us to investigate. Reporting failures are glaring. We get most of our information in evaluating these cases from Paris when the report's not on Paris. At this point, ecology's got it together that it's usually not their problem. It's usually that the report hasn't been submitted. That's a total red flag that something's not right at the facility and may prompt a notice letter. The biggest current issues in litigation right now, I would say there's one. And that is about the footprint of the scope of coverage footprint for the category of facilities covered by the industrial stormwater permit, that is transportation facilities. And for whatever reason, EPA and its regulations limited the definition of stormwater associated with industrial activities at transportation facilities to areas directly associated with maintenance shops, which is itself kind of a vague term. The Department of Ecology decided that the entire transportation facility ought to be covered if it has a maintenance shop. This is different than what the federal permit requires. This is an expansion of coverage. Ecology made this change first in the permit in 2010, and there's notably a letter from the then head of Ecology's water quality section to the port industry, the marine terminal industry, explaining this. They didn't appeal it in 2015 when the permit was reissued like that. The issue has arisen in a big way in one of our citizen suits down in Tacoma against the Port of Tacoma, and APM and SSA It's in front of Judge Bryan. This is an issue, Judge Settle. This is an issue he seems to have gotten far in the weeds from. He requested an amicus brief from Ecology. We have cross-summary judgment motions pending on this for approaching 2 years now. This is also the subject of the present appeal of the recently issued industrial stormwater general permit, in which those same defendants in our citizen suit are trying to challenge this expansion of coverage. They're trying to claim that it was not properly done under the federal authority and all these kind of, I think, let's call them creative arguments that I don't really think have much of a chance of winning, but that's kind of the big issue going on right now. So that is that's relevant to transportation facilities, particularly rail yards and facilities with overwater facilities are a big deal at these transportation places. I'm talking about marine terminals. And there are a lot of issues at marine terminals, and whether the piers are in the permit is a big deal because piers are typically very old infrastructure and do not do a good job of managing stormwater. And there's some really dirty stuff that sometimes happens out on the piers. In addition, marine transportation facilities are transporting things on and off of ships and docks, and stuff falls in the water. So that's kind of a related issue there that has arisen in a number of cases recently. So other things going on right now, I mentioned the unauthorized non-stormwater discharges, and this is from ship loading and unloading, stuff falling off in the middle in the gap. Stuff blows off material piles. That's not a stormwater discharge. That's a illicit discharge, a direct discharge. The boatyard general permit is being reissued. I don't know what they're going to do with that thing. I was involved with Puget Sound Keeper Alliance several years ago in extended negotiations with the Marine Trade Association and the Department of Ecology. We finally found the problem at the boatyards is copper-based bottom paint, and do-it-yourselfers operating at boatyards that often are very old infrastructure, right on the water, a lot of potential for people doing bad stuff that makes a mess with copper. So the way we resolved it before was we kind of figured that there was this major effort to replace copper-based bottom paint, and that this was a short-lived effort that we could just, finesse for the moment. Well, now we learn that there is not going to be any replacement for copper-based bottom paint, and I don't know what they're going to do with the copper effluent limitations in the boatyard general permit. The boatyards are going to will be exceptionally challenged to meet the very low copper benchmarks in the industrial stormwater general permit, and I cannot think of any legal rationale why the boatyard general permit should have copper benchmarks that are less stringent than the ISGP. So I don't know what's going to happen there. I mentioned before, we're looking for some other MS4 type of cases. We're investigating MS4 liability for maintenance of best management practices, particularly when the MS4 permittee is a landlord at a permitted site. We're looking for whether the MS4 jurisdictions have all the stormwater pollution prevention plans they're supposed to have for other facilities that aren't otherwise covered, for industrial facilities that aren't otherwise covered. And we've also noticed that there may be some issues with illicit discharge detection elimination programs. Some of the MS4's permittees are landlords to unpermitted ISGP facilities, unpermitted industrial stormwater general permit facilities. And there may be some MS4 liability in those cases as well. Finally, this regime has been in place long enough that we're coming around for second and sometimes even third rounds with facilities, either as citizen suit defendants or as facilities that have triggered requirements to implement stormwater treatment. And some of the stormwater treatment that went in 10 years ago or so is proving now to be inadequate, either because people have failed to maintain it, there was some flaw in the design, or because they just messed up the design and failed to capture all of the stormwater discharges at the facility, which I think is a really unfortunate problem that happened to a surprising number of places. So that's kind of what may be in the cards, what's to look for, at least from my perspective. So that's what I got for you.
Thanks, Richard. Oh, and I assume you're okay with me just jumping right in? All right. So Richard and I, as you might have anticipated, are almost always on the opposite side of an issue. And I think the best analogy I can give you for what you just heard from Richard that I think is applicable today is we all need to learn some new habits and some better habits. If you want to avoid Richard and his clients showing up at your client's doorstep, you need to do a better job of washing your hands. You need to remember to wear your mask. And really that boils down into, in the clean water context, if I could figure out, Richard, what'd you figure out how to move the slide forward? There we go. How do you avoid citizen suits and enforcement? And then how do you resolve them if you are unfortunate enough to encounter one? And the first issue is really maintaining permit compliance. And the second one is looking at ways to get out early, largely because the longer you stay in the process of a dispute over a permit or a Clean Water Act compliance, the more sharply the costs go up. And it's a significant factor here. Oftentimes the problem can be solved more cheaply than fighting about the problem. And I'll get into that in just a moment. So how do you avoid? If a permit's required, obtain coverage and maintain compliance. It's really that simple. And don't forget that, as Richard pointed out at the outset, this is an extremely broad law. Basically, anything that's not water is a pollutant. So if you put anything out there as a result of your activities and you're subject to Clean Water Act compliance, you should get a permit. Now, I don't want you all running out and getting a permit and saying, wait, I got a permit and now Richard knows where to find me because he looks at Paris and he looks at all the list of people that have permits. It's harder for those doing citizen suit enforcement to take enforcement against somebody who should have a permit that does not than it is against somebody who should have a permit, has a permit, and is not doing what they should under the permit. And oftentimes this question comes up, should I have a permit? Well, that's the threshold question. And there are many parties out there that have permits that don't need them. And basically it boils down to, in the industrial stormwater context, are you conducting an industrial activity that's within those that are listed? And are you exposed to precipitation, whether it's rain, snow, whatever? Do you have natural water hitting your property in a way that is creating an opportunity for pollutants, the result of your work, to make their way into a water body? And if that's the case, you should get a permit. And once you have a permit, the thing that seems to be hardest for people once they have it is maintaining compliance. And that gets down to prioritization. Is your business going to prioritize doing what you need to do to take care of compliance with the permit? And oftentimes clients will come to us because they delegated the job of ensuring permit to compliance to the wrong person. And that person doesn't know what they're doing, hasn't been trained, and is just being asked to go check some boxes. One thing you're going to see later on in my materials is a recommendation towards using environmental consultants like Owen and using lawyers like Veronica and me to help evaluate whether you're in permit compliance, whether you need a permit, so you can avoid some of this. And one of the first things to do is ensure that your discharges are within the permit standards. Just remember the list that Richard showed. How do they find you? Well, they go to publicly available information and they see if you're doing what you're supposed to under the law. And every time they see something that's out of compliance, it increases the likelihood that they're going to send you a notice letter. So one is ensure that you're in compliance. Two, prepare a stormwater pollution prevention plan. And it's surprising how often someone will receive a notice letter, they'll reach out to somebody for help, and the first question will be, may I see your stormwater pollution prevention plan? And the answer is, a what? And sometimes it's just a confusion on terms. Oh, your SWIP. Oh, I know what that is. But oftentimes it hasn't been prepared. Or if it has been prepared, that hasn't been prepared correctly. So doing a facility assessment, putting together a really good map that shows how your stormwater flows over your property, how it relates to your activities, putting together a monitoring plan, describing which best management practices are applicable, all of the things that are laid out in very clear terms in the permits are the things you should be doing. So read the permit, get the permit, read the permit, comply with the permit. And then another thing that often becomes an issue is timeliness. So did you perform the sampling when required? It's very common to find out that sampling quarters were missed for whatever reason. I was too busy. Oh, I thought someone else was doing it. All of these different things. And again, it goes back to establishing good habits that may not be intuitive to the business because they're not the core of what you're doing. For most business operators, they're trying to run their business. They're not worried about these type of issues that they view as collateral or secondary. But they're only collateral or secondary until you face some sort of an enforcement action. And the less attention you pay to these things, the more likely it is that you're going to face this type of situation. Consistently submit your discharge monitoring reports to Ecology. As Richard said, they look on the database, on the Paris database that Ecology maintains. And one of the things that jumps out to them is inconsistent or complete lack of discharge monitoring reports and regular reporting. And when your reports tell you that you're out of compliance and that you've tripped a benchmark, then take the corrective actions. And that's another thing that you find is, well, we're doing everything right. Well, yeah, you're doing everything right, except ignoring the fact that you had a benchmark exceedance and you have things that you need to do to correct that. And then finally, comply with the permit's record keeping conditions. Again, if you don't do all the things that need to go in the records and properly submit the records to Ecology, then you're just waving a flag around saying, come look at me. And I'll tell a little story of a situation. I was with my family traveling in New Zealand, and we were doing some underground caving, and the guides described the Haniwa. And the Haniwa is a fictional local creature that lives in the caves and hunts for people. And they told one of my sons, they said, would you like to be the protector from the Haniwa? And he said, yes. And they said, okay, turn around. And they took some mud off the floor of the cave, and they did some spreading of the mud around on the back of his wetsuit. And they said to him to turn around to the rest of us. And what they had drawn on the back of the wetsuit was a target. And that the protector from the Haniwa was the guy who had the target on his back. And so just remember that the way you get the target on your back in this instance is to not do what the permit requires. So how do I do that? Well, some additional tools for compliance. One, the permit itself, but then you can ask for technical assistance from the Department of Ecology. And the fear would be, oh, am I asking Ecology to come take enforcement action? Well, the likelihood that Ecology is going to take enforcement action is actually, in some respects, lower than the fact that a private citizen group is going to take enforcement action. One, it's a resource issue. And two, they have this requirement that they provide technical assistance. So if you go to them before you've done something wrong, or before somebody's figured out that you've done something wrong, and you say, would you please help me comply? Then you're increasing the likelihood that you're not going to face enforcement, and you're taking a step that's helpful to moving in that direction. The next thing that I foreshadowed for you a moment ago is hire a consultant. Hire somebody who does do this on a regular basis to help you sort through what does the permit require and how do I do it best. And there are lots of very good environmental consulting firms that are out there to help you. Many of them are probably listening to this conversation today. And they're listening to this conversation so that they know how to do their jobs better and that they're ready and available to do that. And the cost that you spend on an environmental consultant to help you prepare for how to best comply with your permit will in most instances outweigh the cost of the risk that you find out later that you weren't in compliance. And so it's money well spent. It's a little bit like routine maintenance on your car. If you go in and get the oil changed regularly, change the brakes when they're worn out, then it's less likely your car is going to break down in the middle of your new road trip that's been necessitated by the fact that you can't fly. Then included in that is get some advice on the permit's technical requirements. Oftentimes, sampling exceedances are a result of poor sampling. And things like dipping the sample jar into the sediments in the bottom of the catch basin. Simple little things that some slight adjustments can really change what's going on, or changing your best management practices so that you conduct more of your activity under cover than out in the yard. Those kind of things can be really helpful. And then similarly, in a preventive way, it's often also useful to get some advice. So what are the hot button issues? Where are the enforcement resources going right now? Well, you just heard Richard say that they're going to seaport type of activities, overwater activities, these transportation related activities. If you were listening to this call and you have a client or you're involved in that type of work and you haven't received a notice letter from Richard, one of two things is happening. You're either doing everything really well or you're lucky. And if that's the case, it's probably a good time to hire somebody to give you some help on those type of issues. Similarly, these permits are constantly being reevaluated and reissued. And when they're reissued, new issues come up and people go through them and they look at things to address and they change. So for example, we used to use SIC codes. Now we don't use SIC codes. Well, that's actually a fairly significant adjustment potentially, because there are some differences between the NICS codes and the SIC codes and how they fit. And that type of change can cause some differences in whether you're covered or not covered. So now moving on to avoiding or resolving them if you do it. So the advantages of an early settlement are, one, it gives you a chance to take corrective action. So remember, you've got this 60-day window. You get your notice letter and you have a chance to do something. Well, if you don't have a stormwater pollution prevention plan, good time to get one. If you don't have a map for the stormwater pollution plan, let's get one. Because what the letter will invariably allege is that you don't have one, because the stormwater pollution plan doesn't have to be filed with ecology. And so that's your chance to take care of some housekeeping. I look at it a little bit like, this is my opportunity to make the adjustments that I wish I had before my mom dropped in unexpectedly and told me to clean my room when I was a teenager. And so this is your chance to really avoid some costs by acting quickly. You can lower your transaction costs at this point because it'll reduce the attorney's fees that you spend on both sides. You don't want to spend as much time wiggling on the hook unnecessarily than you have to. And so that's one way you can reduce it. One, if you settle before you get into litigation, you can stay out of federal court, which has lots of procedure and lots of costs. And two or three, you can avoid the Department of Justice involvement, because they also get involved, because if you try to settle once you've got a suit, you've got to get their approval for the settlement. And then lastly, it might be a chance to avoid some negative publicity. One of the ways that citizen groups pump up their membership is by trumpeting out what they've done. And so if they can point to a significant success, they're going to do it. That's how they support their groups and justify the work that they're doing. And you don't want to be the poster child for a citizens group success when you could have avoided the whole thing by either not getting caught in the issue in the first place or reduced your costs by settling early. So those are some of the advantages. That means you've got to act quickly. And this timeline will give you a sense. Within those first 60 days, response letter in 5 days, you got to do your internal review also in 5 days. That's a week of work days. So you've got to move really fast. Do you have time to update your SWIP? Well, I don't know. Is there a SWIP? Have I communicated with the client? Do I know who's responsible for taking care of stormwater compliance? All of these things have to turn around pretty quick. And the citizens group will not settle, in my experience, without an opportunity to come to the site and see it. So you've got to figure out the schedule. Well, with COVID, now you've got an additional layer of figuring out, can people even get there? Do they have their masks? Can we do this? You know, what are the additional logistical challenges there? Then you have to have time for the actual negotiations, select the potential supplemental environmental project, draft the settlement, and reach some agreement. If you don't do all that within the 60 days, they will sue, because as Richard has shared with me on many occasions, because we've had this conversation, they're concerned about jurisdictional issues if they don't move ahead with the litigation in that 60 days. So they will almost invariably bring an action if there's not a resolution within 60 days. You can't count on, oh, we just need another week to pencil out the settlement agreement. So it really is important, if you're going to achieve those cost savings and efficiencies, to move quickly at the front end. I think I've touched on most of these other things. Richard touched on the penalty. Payment in lieu of penalty, Veronica's going to talk a little bit about some challenges on that note. And then just remember that it's reasonable attorney's fees. And you may have a disagreement about what's reasonable, but oftentimes the citizen groups will want to pursue that if they can't reach some agreement. So don't expect a significant cut in what they think is reasonable. When Richard shows up with an associate, it drives my clients crazy. Kind of drives me crazy too, when I think one attorney can do it, but it's going to be really hard to convince him that we shouldn't be paying for 2 attorneys to try to settle the case when that's one of the last outstanding issues. There are some issues here. One last thing I want to mention is this diligently prosecuting. There is something called a permit shield, but there is a hesitancy on the state, on the enforcement agencies to jump in here. And this is a particular policy of the Department of Ecology, is they don't want to allow the citizen groups to drive their enforcement prioritization, their prosecutorial discretion. And so they will generally not step in a situation where you've already received a notice letter. So the best way to deal with the agencies is to engage them early on before you get some sort of a ping from the citizen groups. 5-year statute of limitations, there is one, and then there's the issue of ongoing violations that Richard just mentioned. Really, at the end of the day, the counterweight to all of this is that it can become very expensive to defend these. And so unless you think you have an important policy issue or a significant flaw in the legal or factual arguments that the citizen group is bringing, it's often more cost effective to settle, even if that involves installing some fairly expensive treatment systems. That's not to say that I'm advocating rolling over and playing dead. I'm an environmental litigator. That's what I do. I take cases to trial. But in this context, there are a lot of reasons why it's often more effective to settle early and try to resolve it in a way that avoids further litigation. Thank you, and I'll turn it over to Veronica.
Thank you, Jeff, and thank you also to Owen and NEBC for allowing me to present. I'm excited to be here. So as Owen introduced me, my name is Veronica Keithling. I'm with Stoll Reeves. A large part of my practice involves defending companies and large infrastructure against citizen suits. So you've heard quite a bit about settlement agreements and what goes into them, but one of the couple of things that I want to point out, one in particular, is that there are generally 2 types of settlement agreements that we'll see in cases like this. One of them is consent decrees, and the other is sort of a garden variety out-of-court settlement. With consent decrees, there are some very specific requirements. The consent decree must be approved by the U.S. Department of Justice and by the Environmental Protection Agency, as well as the court. These approvals are done ahead of time before the consent decree is entered into the court record. But once it's approved, it does become a part of the record, and it is something that's publicly available. So those are considerations in deciding that you want to go the consent decree route. One of the advantages for the company that's been sued with a consent decree is that the consent decree precludes the citizen group from refiling a lawsuit against the same company for the same violations. In essence, it stops them from having a second bite at the apple for the same alleged violations with the same company. In contrast, the other potential type of settlement, as I say, is an out-of-court, more kind of garden variety settlement that does not require approval from the U.S. Department of Justice, the EPA, or the court, and it does not get entered into the court record. So the court has no ongoing jurisdiction. From a practical standpoint, what that means is that then the parties would have to go back to court in a new action to be able to enforce the settlement agreement. So there are advantages and disadvantages on each side, but the majority of citizen suits are settled through a consent decree. Richard and Jeff have done a great job of talking about the different components of consent decrees. There's a list here. The thing that I would add about consent decrees or any type of settlement in the citizen suit is that it is a negotiation between the citizen group and the company that's been sued. Richard gave you a list of the things that they're going to ask for, and those are listed here. But that's a negotiation point. It's not a take it or leave it generally from the group, from the citizen group. There usually is some room for negotiation. And for the defendant, for the company who's been sued, there are a couple of key questions to ask yourself as you work through those negotiations. The first one is are the things that the citizen group asking for things that the court could require the company to do through this lawsuit? For instance, if the citizen group is asking you to install treatment to try to get your discharges down below a benchmark level, absolutely. That's something that a court could ultimately order the company to do through a Clean Water Act citizen suit. However, if the citizen group is asking the company to change the hours that it operates because the trucks are loud and they're annoyed by the noise, that's not something that a court generally is going to be able to order in a Clean Water Act suit. And so there may be room to negotiate more on items that a court couldn't order. The second main question that it's important for defendants to ask themselves, and Jeff made reference to this also, is what can you do going forward? What are you willing to do going forward? Consent decrees usually have a time in which they're effective, 2, 3, even 5 years. So commitments that a company makes, for instance, sending reports to the citizen group or doing additional monitoring, are generally going to be requirements in the consent decree that could go on for years. So recognizing that and being sure that you have the ability and the willingness to do these things are going to be important. There are also a couple of items that certainly are considerations, asks that a company can make in settlement that will be to their ultimate benefit. One of those is the last item listed here, the complete release of known and unknown claims. The defendant company certainly has the opportunity to ask the citizen group to expressly state in the consent decree that the citizen group is releasing and will not sue on claims that they know about now or that they may discover in the future during that 5-year statute of limitations, going back from the time of the lawsuit in time, 5 years. It provides, again, some finality and certainty for the company that once this case is settled, it's settled and done. The other item that we often encourage our defendant companies to include is an express statement that they're not admitting fault. A settlement is not, it has not in any way determined through the court that an allegation is true or that the permittee has violated the permit or the Clean Water Act. And it's certainly something that defendant companies can ask to have included in the consent decree, that they're not admitting fault. So that gives you an idea of, through all three of us, we've talked about how a case moves forward, some of the things that lead up to a case. Richard pointed out some new issues that we're seeing in Clean Water Act and particularly NPDES suits. And there are 3 more that I'm going to touch on really quickly because I know we're running out of time and I want to make sure that we have time for questions. But the 3 recent developments, additional developments that we're seeing that could affect citizen suits and almost certainly will affect NPDES permitting going forward are the U.S. Supreme Court decision related to groundwater that came out earlier this year in County of Maui. Second, potential landlord liability for tenant actions under the tenant's NPDES permit. And then the U.S. Department of Justice's changing viewpoint on supplemental environmental projects. So first, earlier this year, the U.S. Supreme Court issued a decision stating that groundwater can be subject to NPDES permitting. The court did not find that all groundwater can be subject to NPDES permitting, but that in certain circumstances where the groundwater discharge is the functional equivalent of a direct discharge, then it would be subject to permitting. A few facts about this case will help, I think, make this at least a little more clear, although the Supreme Court wasn't very forthcoming on exactly how we were supposed to apply this test. But in the County of Maui case, the facts were that the County of Maui has a number of injection wells that discharge water that under the Clean Water Act is considered to be polluted. So the injection wells are a point source that then discharges into groundwater. The discharged water travels through the groundwater and then is discharged through a discrete, discernible location into a navigable water, which was actually the ocean. And what the court said is that there could be circumstances, they didn't decide whether County of Maui's injection wells qualified, but there is the potential that these discharges through groundwater could be equivalent, functionally equivalent to a direct discharge, in which case then they would be subject to permitting. This is an expansion of jurisdiction under the NPDES federal program that then has been passed down to the state of Washington. In that, in the past, we were not certain when groundwater or if groundwater was subject to regulation under the federal NPDES program. In Washington, it's probably not going to look a lot different because the Industrial Stormwater General Permit and a number of individual permits already regulate groundwater. And that's because in Washington, we have a combined state and federal permit. It's issued both under the delegated NPDES program from the federal government and then also under the state discharge statutes. But the takeaway is that now in certain circumstances, groundwater can be subject to a citizen suit under the NPDES program. So the second area where we're seeing the potential for expansion in citizen suits is where a landlord could be potentially liable for a tenant's actions. This occurred here in Washington, where a citizen suit was filed against an NPDES permittee who happened to be a tenant of a public port. The citizen group eventually added the public port landlord, alleging that the landlord was also liable for the tenant's actions that allegedly violated the permit. The port went to the court, filed a motion questioning whether they could be liable for a permit that they didn't have coverage under. It was the ISGP, and for actions that they didn't take. And the district court for Western Washington disagreed with the port and found that a landlord might be liable under certain circumstances for tenant's actions under the tenant's own NPDES permit. And some of the factors that the court was considering were the amount of control that the landlord had over the actions of the tenant, how much direction the landlord gave to the tenants, and whether the landlord was actually directing or causing the violations themselves. So this is an area where we may see additional litigation going forward. And then finally, the U.S. Department of Justice, as we discussed, has to approve consent decrees before they can be entered into the court and finalized. And one of the main components that we see in consent decrees for citizen suits, like the ones we've been talking about, are supplemental environmental projects. The Department of Justice issued 2 policy statements over the last year that essentially say that in EPA enforcement settlements for violations under NPDES and other citizen suit or other environmental statutes, that a SEP cannot be included in those enforcement settlements. So I realize that EPA enforcement is not what we're talking about here today. We're talking about citizen suits, but these recent policy statements by the Department of Justice indicate that DOJ is changing its 20-year view now of supplemental environmental projects. And actually just about 6 weeks ago, Jeffrey Clark, who is the U.S. Department of Justice attorney who supervises the review and approval of consent decrees for environmental cases, stated that while the Department of Justice does not anticipate that it's going to issue an official policy or memo on supplemental environmental projects in citizen suits, he did say in the interview that that DOJ will continue to oppose supplemental environmental projects as part of citizen suit settlements. So this is not an official statement from DOJ. It remains to be seen whether the Department of Justice will begin disapproving or failing to approve consent decrees. I haven't seen that happen yet, and I'll let Richard chime in if I get this wrong, but to my understanding from Richard is he hasn't seen the Department of Justice refuse to approve consent decrees on that basis, but it's a concern going forward. My apologies for talking so quickly, but I did want to give us a couple minutes for questions, and I'll turn it back over to Owen. Thank you.
Thank you, Veronica, Jeff, and Richard. We have had a couple questions. We have had a couple questions come in the chat. Thank you for asking them. I'm going to take them from the top. And the first question is future-proofing ever a consideration when implementing treatment in response to a citizen suit? Examples being considering the future and potential lowering of benchmarks or long-term O&M.
I'm not sure I totally understand the question, but sometimes we do, as part of settlement, have defendants agree to go above and beyond what's currently required. Typically, that's in anticipation that the requirements of the permit might be made more stringent, or that the facility might need this additional BMP or treatment or whatever it is in the future. Facilities that are willing to go above and beyond what's required for compliance will sometimes be given a break on the penalty piece, quite frankly. So in a sense, yes, the above and beyond anticipating future requirements and preparing for them now is something that does happen, but the citizen suits can never control or address what might be in future permits, because those are written by the Department of Ecology. So, whatever my clients and a permittee might agree, the Department of Ecology does its own job.
I would add to that, you can reach a contract that sets a different standard, but you can't reach a contract that sets a less stringent standard than the law requires. So if you're future-proofing, anticipating a change that's going to be more favorable to the permitted party, that's a challenge, because you may get it wrong, and then you're going to be out of compliance if you hit a contractual standard that's less stringent than the statutory standard or the regulatory standard.
Thank you. Our next question, I think, is for Jeff or Veronica. What have you seen to be the most convincing argument a facility operator can make to their management when they're questioned about spending money on stormwater maintenance or hiring consulting support?
I'll take the first crack at that, Veronica. $55,800 per day per violation. The numbers add up really quickly. That's not to say that that's actually what's going to happen, because that number is the maximum. But the problem is with the penalties here that it's not very difficult for the citizen group to show a fairly high frequency of penalties. So you get a variable that multiplies fairly easily. So it's a cost issue. It's just like the car. The preventive maintenance cost is often cheaper than the replacement or repair cost if something goes wrong.
I would absolutely agree with Jeff that is one of the most compelling arguments that you can make. The additional argument that often will help is failing to install maintenance is failing to maintain, failing to meet the requirements of the permit is going to cause problems down the road that may make complying that much more difficult. And so as Jeff said, trying to maintain and fix the problem now before it becomes a bigger problem where you're negotiating what those fixes might be can also be an issue.
Yeah, I guess I would add one last point, and I mentioned this before. The cost for your opponent's attorney's fees, they're not going to settle without that in some fashion. You might be able to negotiate it down to some degree, but you're going to pay a substantial portion of that. And many of those costs are incurred before you ever hear from them. So it's a really hard, almost an unavoidable cost that can only be avoided by seeking to maintain and not ever get in that situation.
Great, and we have one last question. Once a settlement is agreed to, who ensures that it is actually implemented? Richard, that might be one for you.
Yes. So now I have done scores of Clean Water Act citizen suits, and I have files full of consent decrees, and I cannot follow up on everything, and I don't get paid for doing that. So I'm typically not doing it. Who's doing it is my clients. We typically set up these agreements with some type of reporting to us. Typically, it's just send us a copy of what you send to the department on a quarterly basis. And I trust my clients to review that stuff. And once in a while, I will get a call that, hey, there's some problem, or these guys doing what they're supposed to do. And we call up their lawyer and we find out what's going on. So there is follow-up. It's done by my clients, by volunteers and nonprofit organizations. It's not done perfectly.
Veronica, I would add to that, but I didn't want to jump in front of you.
Go right ahead.
Okay. So there's a distinction here between a settlement agreement and a consent decree, and it's important. If you violate a settlement agreement, then there's a possibility of somebody going in to enforce it. If you violate a consent decree, then somebody who's going to be enforcing it is a federal court judge. And the instances that I've seen where parties have been out of compliance with a consent decree and the party that sought the consent decree has had to enforce have gone very badly for the party out of compliance with the consent decree. Federal court judges don't want to see you again if you've got a consent decree. And if there's a fight over the consent decree, it's another instance where it's better to try to work out an agreed deal instead of putting it in front of the judge. But Richard's clients may not be telling him what they're doing, but I've seen the traffic on the emails where his clients are communicating with my clients and they're on it. They're definitely making sure that they're receiving their documents and that things are happening the right way, and they're asking questions when they don't. So it should be the parties, and it should be, if you're representing a party who entered into a settlement agreement, then you should be setting up a way with consultant help often to make sure you're complying with it. That if you said you're going to put a treatment system in, get it installed, make sure it works. Get your documents filed with ecology, because there's nothing that can prevent a citizens group from filing a new action for new alleged violations. So the settlement doesn't resolve future problems, it just resolves past problems.
And just to echo what Jeff said, it should and is the responsibility also of the permittee of the company to follow through on the things that it committed to do in the consent decree. And often those have also become a part of the agreement that it has with ecology going forward. So certainly the parties, as you say, both have an obligation in making sure that the consent decree is carried forward.
The last incentive I would mention is the cases I've seen that have come back around, where the citizen group has shown up a second or a third time. It gets harder to settle because they have less trust and they're seeking greater penalties or greater costs, and they're not willing to cut you the same deal the second or third time.
All right, and with that, I think it wraps up our time for Q&A this afternoon. I'd like to thank our panelists, Richard, Jeff, and Veronica. Thank you, that was fascinating. And I'd also like to thank NEBC for once again hosting the Managing Stormwater in Washington conference. Greg, I'll hand it back to you.